Tonight we are talking about the details of the new genuine student requirements and also how the department's website errors could cost hundreds of visa applicants for the points-tested visas their dreams of obtaining permanent residency. Hi, I'm Karl Konrad and welcome to our weekly edition of Australian Immigration News. This channel is proudly brought to you by Australian Immigration Law Services, right here in the heart of Sydney. Finally, as announced in the Migration Strategy release on the 11th of December last year, the Australian Government is replacing the Genuine Temporary Entrant requirement, known as the GTE, for the grant of a student visa with the Genuine Student requirement. The GS requirement is planned to commence for student visa applications lodged on or after the 23rd of March. Those student visa applications lodged before the 23rd of March will be assessed according to existing arrangements. When it comes to student guardian visa applicants, the current GTE will continue to be applied. This new genuine student requirement is designed so there is no confusion that they fail in the application simply because an applicant may indicate they may wish to migrate to Australia. The focus will be on international students with circumstances that support a genuine intention to obtain a quality education in Australia. The current 300-word statement required in the student visa application form will be replaced with targeted questions. These questions are meant to be able to give case officers an overview of an applicant's reasons for wanting to study in Australia. The intended questions will cover details of their current circumstances, including ties to family, community, employment, and economic circumstances. An explanation for the choice of the course and the reasons for choosing Australia as a study destination. What benefits the course provides to the applicant. For applicants with a study history in Australia, details of their study history. For applicants holding a visa other than a student visa, their reasons for applying for a student visa, and any other relevant information the applicant wishes to provide. Student visa applicants will be required to sign a declaration to confirm the following. Understand what it means to be a genuine student for the purpose of studying in Australia. Have read, understood, and commit to comply with student visa conditions, and to notify the Department of Home Affairs of any changes to their circumstances, and understand that while post-study pathways to permanent migration are available, only a limited number of graduates will be eligible, and those who are able to remain lawfully in Australia must depart Australia. And there you have it, that declaration they will remind you for the rest of your life. Student visa applications that were lodged before the 23rd of March will continue to be assessed under the current GTE requirements, given under Ministerial Direction number 69. When the new GS comes in, expected on the 23rd of March, all applications will be assessed under the new criteria. It is clear that this new GS requirement is designed to force international students to acknowledge that further PR pathways will be limited, and it's expected that those who cannot find one are expected to leave. Will this be enough, however, to deter students from coming to gain permanent residency? I do not think so. Well, this new student test is very disappointing. There is still plenty of elements of the GTE in the new GS, enough for case officers to refuse any visa applicant they want to. For example, most applicants from specific countries could be rejected on the basis of economic circumstances alone, and the government will continue to use this excuse to refuse applications en masse when they feel the need for it. The new GS, however, does make it clear that the government wants to make the opportunity for international students to gain residency much more restrictive than it is today. How exactly they're going to achieve this is still unclear, but we know already by reducing the times available for the 485 visa and reducing the age requirements will be their first steps. It's a big gamble for Australia's fourth largest export industry, and it's one that could easily blow up in the Department of Home Affairs Minister's face. A significant collapse in international student revenue coming into the country will have severe economic impacts to Australia today, and particularly at a time we can least afford it. Can you really trust what the Immigration Department puts on their website? For recently, many people have contacted us about the Skilled Migration Points Test, specifically about the allocation of partner points and those who claim 10 points as a single applicant. The department is now processing these applications they put in the too hard basket. Many of them have been waiting years for their visas to be processed, some over 4 years, but have married or entered into a relationship since applying. This generic request letter is being sent out after the department learns that a single applicant is no longer single. Now, these generic requests state the following. From the information and evidence before me, it appears you may not satisfy the requirement that the applicant does not have a spouse or de facto partner. Therefore, you may not meet the requirements of 6D.11 and Schedule 6D of the Migration Regulations that would allow the claim of 10 points under this criteria. To justify this statement, they are not sending applicants a copy of the regulations, which they should be doing. Rather, they are giving them a link to their own website, saying, if you believe you are eligible for additional points under another part of Schedule 6D, please update your information on your IMI account. Now, at the office here, we rarely look at the department's website, for we rely on the regulations instead. However, when I took at this link, I was horrified. Then I checked these points tables for the 189 visa and the 491 visa as well, and they were all exactly the same. The very first statement made on these points tables on their website is completely incorrect. It states, points criteria are assessed at the time of invitation. This wording clearly implies that all points criteria are assessed at the time of invitation. This is not true, for partner points and state sponsorship points are assessed at the time of decision. That is, when a case officer looks at your file and makes an assessment. However, when you scroll down this Home Affairs page and you get to the partner points table, it mentions nothing of this fact, so people are being misled into believing their partner points were frozen in time, just like all the other points assessments. Now, there's good reason most points are locked in at the time of invitation. If you turn older during the processing and you fall into another age bracket, it does not matter, for your age is set at the time of invitation. If your English language test results expire after you apply, they will still be valid and locked in at the time of invitation. If your skill assessment expires, it was valid at the time of invitation. If your professional year program expires, it is still valid at the time of invitation. If your NAATI credentialed language points result expires, does not matter, for it was valid at the time of invitation. If you lose your job and you're no longer working in your skilled occupation, it won't matter, for the work experience points are set at the time of invitation. So you can see people need to rely on what the department says regarding the time of invitation, because it could take a considerable amount of time to process your visa points. In fact, there is nothing on the department's website anywhere at the time we're making this video that indicates partner qualifications are not set at the time of invitation, and they will be assessed separately at the time the case officer is allocated. Even in the standard invitation letters sent out to all EOI applicants so they can lodge their 189, 190 or 491 visas state the following. Most skilled visas have requirements that must be satisfied at the date of invitation for a visa application to succeed. And when you make your IMI account and fill out that application form, again, there is no warning that partner qualification points are assessed not at the time of invitation, but at the time of decision. We outlined all these concerns to the Department of Home Affairs in a media inquiry, showing them the website and the request letters, etc., and asked the Minister Andrew Giles to respond. We asked him just one simple question. Does he mean to refuse visa applicants because they relied upon the department's website? However, when the response came back, not a word from the Minister, but from the department's spokesperson, stating, the information on the website of the Department of Home Affairs is only intended as a basic guide to the relevant laws and does not address the complexities of particular circumstances. Well, that's just great, isn't it? Now it's official. You definitely cannot depend on anything they put on their website and expect them to be accountable for the information they provide there. And in fact, they are deliberately dodging any accountability by saying applicants should seek independent advice about their individual circumstances. Simply amazing, isn't it? They can get away with having false information for more than 4 years on their website and take no responsibility for it at all. This callous response from the Department of Home Affairs is also reflected in the manner how the 476 visa applicants were treated. And again this week we have another example when they cancelled numerous visitor visas of Palestinians fleeing war-torn Gaza seeking some respite in Australia. Many of these poor people affected by these sudden cancellations were in fact stranded mid-country and nowhere else to go. If you are concerned about these events, don't forget to voice your concerns on the government MP Facebook pages. If enough people lodge their protests, then just maybe the minister may step in and fix these injustices. Well, that's enough for 1 week. Don't forget to subscribe and hit that notification bell so you won't miss out on any changes coming up. Remember, if you need help, we are always here. Book a time by visiting our website or just pick up the phone. As always, take care out there and I'll see you next time. So bye for now.